If you're ready, Michelle?
Yes.
Great. This meeting of the Arizona Independent Redistricting Commission will now come to order. Today is May 2nd, 2013. The time is 2:37 p.m. And why don't we start with the Pledge of Allegiance. Vice Chair Freeman, could you lead us?
Sure. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great, thank you. We'll go ahead with roll call. Vice Chair Freeman.
Here.
Vice Chair Herrera. Commissioner McNulty. Here. Commissioner Sturts.
Here.
We have a quorum, and I understand that Vice Chair Herrera will be joining us around 3 o'clock. So we'll go ahead, though, and do what we can in his absence. Other folks in the room include our legal counsel, Joe Canefield and Mary O'Grady. We have our Executive Director, Ray Bladine, and Deputy Executive Director, Christina Gomez. Our Information Technology Specialist is Buck Forst. Thank you, Buck. And Michelle is recording the proceedings today. So everyone be mindful since we're on the phone. I apologize for last time with me being on a cell phone. It just really didn't work well, and it was very hard on our recorder and everyone else. So hoping this time will be better. Anybody I missed? Okay, hearing.
Yeah, Madam Chair, I'm sorry. Yes, we have Mr. Desmond here in the audience, and
Great.
And we have Mr. Mattori, our regular, and we have Peanut Gallery, and we have Bo from Ballard Spar.
Oh, great, thank you. I remember you told me about Bo. I apologize. Okay, well, we'll, in looking at the agenda, item 2, we started to go into last time, and since Commissioner Herrera isn't here to kind of talk about that, I was wondering if maybe we should start with items 3 and 5, since those are items that pertain to the Executive Director and the budget and things like that. Well, would that work for folks? Fine with me.
No objection.
Fine with me.
Okay, great. Let's go ahead with number 3, report, discussion, and possible action regarding the Commission's fiscal year 2013 appropriations and expenditures and budget issues for fiscal year 2014.
Marcelle's asking me a question. Are we getting?
The microphone for the speaker phone.
What do I need to do? You need to pick up my phone. Oh, I picked up the wrong mic. I'm sorry. Now I understand what I did wrong. Madam Chair, I picked up the mic that was supposed to go to the cell phone to pick up your voice. Sorry. I thought I would ask Christina to do a summary of where we are in the budget now and update you with the latest information on our appropriation for a supplemental appropriation for this year. Christina?
Thank you. Madam Chair, Commissioner members, as you all have probably heard already, Senate Bill 1482 was passed by the legislature last Thursday, and it was submitted to the governor's desk, and she signed that this past Tuesday. And as of this afternoon, the appropriation has been posted. So we now have access to our supplemental appropriation. The total of appropriation to the commission was $635,000. So we're grateful that now we have money so we can now pay some bills. So next week we will be working on fiscal year 14 appropriation. We'll be working on scheduling appointments with staff and with members to discuss next fiscal year. And I'm sorry, Ray, did you want to talk about?
Let's, Madam Chair, unless there's questions, I think we can, we'll just go on and maybe do the director's report and talk about staffing. I would tell you that at this point in time, we've heard nothing on fiscal year 14. Our request is about $2,200,000 and some odd thousand. And I think the problem that everybody's reading in the paper that right now the legislature and the governor are tied up with the Medicaid bill, and nothing seems to be happening on the budget. But we thought next week we'll double back with, as Christina said, the staff and the leadership of the House and the Senate, and just make sure they don't forget about us. They did also, in the bill that Christina mentioned, provided the ability for us to use 14 money to pay bills in 13. We are hoping that the legislature will quickly adopt a budget for 14, so we'll have some money that we can spend against if necessary. But I think this should get us through this fiscal year. But it's a little disconcerting that we don't see movement yet on the 14 budget. But I think we're in the same position as everybody else. So, Madam Chair, if there's no questions, I'll ask Christina to go ahead and talk about the other items in the Executive Director's report.
Do commissioners have any questions for Mr. Bladine or Ms. Gomez on that item? Okay, I don't have any questions either, but I will just commend them for their hard work. They've been going at this for a number of weeks, and I just want to thank them for their diligence and persistence, and I'm very grateful that they were successful in getting some funding. Thank you.
Thank you. So the next item on the memo that went out to you on April 24th, the Executive Director's report, staffing. We still have with us Shane Shields, Lisa Schmeling, and Anna Garcia as part of our staff. Every month we review the workload. We were really busy with the Harris case and helping out legal counsel to keep our costs down. So Lisa Schmeling and Shane Shields did a lot of data collection for legal counsel, but we are reviewing month by month the workload, and we've also looked at what may be coming up. So as far as the workload for the Leach case, and also the outcome of the district court will affect our staffing needs here in this office. So we still have the same staff here with us, and we will continue to monitor this month by month. Facilities, we're still renting the Evans House from the Secretary of State's office. The rent for the fiscal year is $27,000. We will continue to occupy the space until the commission asks us to move, but we will continue to stay here until we're told otherwise. Technology issues, Buck Forrest is still with us, and he's still recording our meetings. And streaming, we have the option to stream at any time. So if the commission wish to start up that option again, we can do that. The cost is $2,400. And we had a question regarding the domain name. That is good until May 5th of 2014. The commission's records, we were in contact with the Arizona Records and Retention last year, and we've also been in contact with library and archives, and they are aware of our office, and they are aware that we may need to close down at some point. So we are still in communication with those two offices. Strategic telemetry log, I believe that's also in your packet as well, so that's the most updated log that we have from our mapping consultants. And the hearing transcripts and minutes, everything is posted on the website. We also have some items too in boxes ready to go, so when that day comes, when they ask us to close down shop, we are halfway there. We're halfway ready to send some boxes, and those meeting minutes and transcripts are, the hard copies are in those boxes presently. So that is about it. If you have any questions, I'd be more than happy to answer those.
Thank you, Ms. Gomez. Any questions for Ms. Gomez?
Madam Chair, Scott Freeman.
Go ahead, Mr. Freeman.
It's been over a week since I looked at it, but strategic telemetry had some bills this year. I think it was $60,000, $70,000. I assume that was
Scott, you're going to have to speak into a microphone, please.
Yeah, I'll try to speak up, but I was speaking right into it. But
Much better, thank you.
you bet. They had about $60,000, $70,000 in bills. I assume that was related to the Harris trial. Had that money been budgeted before? Was that anticipated?
Madam Chair, Vice Chair Freeman, we did our best to estimate their costs. However, with the workload of the trial and everything being so, everything that was expedited, it was difficult to come up with a good estimate. We did project them to be, I believe it was roughly 35,000, and they came close to 39,000. But we did our best to estimate those costs without exactly knowing how much work would be involved in this process. Thank you.
Okay, any other questions? I have a question for Ms. Gomez, since she was involved with the commission last time. Just curious, when did they close down?
Madam Chair, they closed down July of 2009, and we received word, I believe it was in June. So we had roughly a month to pack up our boxes and to shut off the lights, because they wanted us gone. Just to save money, of course.
Okay, yeah, so it went almost the whole decade.
Yes.
Okay. Okay, any other questions?
Madam Chair, I might just comment on the last part of our director's report on that first page under the budget. We did show you, as best we could, an estimate of what we had thought attorney fees might be as compared to what they actually ended up to be. One of the things that threw everything off of our budget, of course, was once the district court said that there was not legislative immunity and that all of the commissioners would be subject to testifying. Our legal costs went up extremely high, both for individual attorneys and also for our commission attorneys who had to respond and work with an additional workload caused by that. We should be able to, as we've talked about, finish out this year utilizing the funds made available and also the funds from 14. I have been reviewing the invoices from the attorneys, particularly looking at March 19th on, because at that point we had asked all of the attorneys to please stop work on the Leach case and also to clear any additional work with our two commission attorneys. and also give us an estimated budget. So I have reviewed the invoices I have to date, which are ones from John Munger, Brian Bergen, and Michael Mandel. I have yet to receive, I think I heard today that we received a bill from Paul Charlton. And I will do the same thing, reviewing them against the scope of work and also against the estimates they provided for the work beyond the 19th. And as I pointed out in a memo to you dated May 1st, I have asked for more information from Michael Mandel about his bill because it was more than he'd estimated. And similarly, I have asked questions of Mr. Munger about some of his items, and also indicated that at this time any additional work on Leach is not authorized, so I could not pay that part. However, I would imagine that if the commission were to approve additional individual counsel after and for Leach, then some of those items could be resubmitted. My memory is that out of his last invoice, about I think $3,000 or so, $3,500 was related to Leach. So we will now start paying off the attorneys that have submitted invoices and try to get caught up to date. And with that, I'm available for any questions.
Are there any questions for Mr. Bladine? Okay, I'm not hearing any. I will just note that, yeah, I've seen the press has covered some of the information regarding individual attorney expenditures, and it's definitely ballooning rapidly. And I saw also this letter from Mr. Bladine dated May 1st. I think it went to all commissioners. It should have. We're all on the letter. And yeah, I guess I'm a little concerned about some of the things. My name happened to jump out. That there's expenditures to investigate me, and I don't know. It says it's not part of the scope of work, but I found that a little interesting. So I'm curious going forward how that's going to be addressed or handled. But I don't know if anybody here can respond to that, since I don't know if that's something Commission Counsel can comment on or not.
Madam Chair, this is Mary. I think the process that is being used is the one that should be used prospectively, where if Ray, when he's reviewing the bills, has concerns about the scope of work, that he follows up with the lawyers submitting the bills and gets the justification to determine whether it's appropriate for payment. And to the extent Commission Counsel can help in terms of categories of expenditures, that makes sense. But definitely, and also trying to do some upfront budgeting as well going forward.
Well, I guess I would just, for the record, then state that they don't seem appropriate, those expenditures to investigate the chair. From my perspective, probably doesn't surprise anyone. But since that's how it's worded in the letter on May 1st, do not seem appropriate, that's what I'll also sign on to as well.
Madam Chair, Scott Freeman.
Go ahead, Mr. Freeman.
A question for counsel. A bill from an attorney often contains attorney-client privileged information in it. How is that privilege being protected by the commission when individual commissioners' counsel send in these bills? It sounds like, I mean, is Mr. Bergen's bills, to me, are they going to be discussed in commission hearings? I mean, arguably there's attorney-client information in there that should not be disclosed. unless I agree to waive it.
Madam Chair, I'm going to let the attorneys answer, but we have treated the bills as not, is client-attorney privilege in responding to both Mr. Mandel and Mr. Bergen. I did not send them copies of the invoice. I did summarize, or I lifted specific items that I was concerned about. I didn't know how else really to communicate it, but I think that at this point, and I didn't, and in the case of, well, and in the case of Mr. Freeman, all I did was summarize in his case that the bill was $791 more than was estimated. And since I did not see that as material, I didn't submit any additional information, and I simply asked, well, I didn't actually even ask Mr. Bergen because I thought it fell within the scope of work. I looked at the dates at which he provided the activity after the 19th, and the amount was fine. In the case of Michael Mandel, his bill was not in dollar amounts but was in hours, and I sent him a memo asking him to explain the difference in hours from his estimate, which was approximately the high end 25, and I think he submitted 36 hours. But again, I didn't provide any of his invoice. And in the case of Mr. Munger, I wrote him a letter and had an attachment with those specific items on the March 18th bill that I was raising issue as to whether they were appropriate and asked for more information. I, again, will let the attorneys answer, but I've been trying to be careful to provide an administrative review of the expenses without disclosing any information, and if I've erred on that, I certainly change it. And the reason I provided the memo to all of you was to not provide you copies of the invoices, but rather to try to explain that in these cases there were some significant charges that I was raising question about. I'd also tell you that I talked both to Mr. Mandel and Mr. Munger about the invoices so that we can continue to communicate. And I guess with that I'll let the attorneys try to address the issue of the legality, but I have been trying to make sure that I do my best to not disclose things I shouldn't.
Madam Chair, members of the Commission, we have talked with Ray about the issue that Commissioner Freeman raises, and we think that the procedure that Ray is following is appropriate to protect the privilege for each of the individual commissioners and their counsel.
Okay, thank you. Any other comments or questions? Okay, well, hearing none, that was also item 5, right? Mr. Bladine?
I'm looking for my agenda.
Or did you have something additional?
No, that is item 5. So we've done really item 3 and item 5.
Okay, and it's 3:01 p.m., so, and no sign of Mr. Herrera, I take it.
Haven't heard anything at our end.
I'm just looking. We have public comment. I don't know if anybody wants to say anything in the public. Are there any requests to speak for him?
No request to speak for him, and our one member of the public shook his head no.
Okay.
Unless Willie's part of the public. He didn't shake his head. Wow, now we've got another item done.
Great. Yeah, we're done with 3, 5, and 6, so we've got 2 and 4. Yeah, it seems like 2 is, they're kind of important topics, and I would presume that Mr. Herrera would want to be a part of them, but I guess we can either recess or we could just go ahead and start talking, see if he's coming, or maybe if somebody wants to check in with him and see if he's on his way or close.
Madam Chair, Attorney Canfield is suggesting we could do item 4 too and have that off the agenda, which was advice, direction to council on our budget.
Oh, okay.
I'll now turn it over to Mr. Canfield since it was his idea.
Madam Chair, I believe this item was put on the agenda in the event that there were any issues with respect to the Commission's request for a supplemental appropriation from the Arizona Legislature. But as we know now, the Legislature has come through with the supplemental appropriation as requested, as summarized by Christina earlier. So I don't think there's any legal action to consider at this point.
Okay, great. Any questions for Mr. Canfield? Okay, we've gotten through the agenda except for number 2.
Madam Chair, we did just text Commissioner Herrera to see if we could get any ideas to timing, but have not heard back.
Okay, thank you. Okay, well, item 2, legal advice, direction to council, discussion and possible action regarding Harris versus IRC, counsel for individual commissioners in ongoing lawsuits and Commissioner Sturtz's request for separate counsel, Leach versus IRC, state legislature versus IRC, and finally access to commission documents, including documents subject to attorney-client privilege or work product protection and executive session transcripts. The commission may vote to go into executive session, which would not be open to the public, for the purpose of obtaining legal advice and providing direction to counsel.
Madam
we
Chair, I
want-
would move,
go
Madam
ahead.
Chair, I would move that we go into executive session for this discussion. I think we need to hear from our attorneys in executive session.
Is there a second? Okay, not hearing.
Hearing no second, I would request that we recess until Mr. Herrera is available.
Okay. Any other comments from other commissioners?
Madam Chair?
Mr. Sturtz?
This is a question for legal counsel. Do you feel that there is anything regarding the discussion of the Leach case that needs to be said in executive, or can you bring us up to speed on that in public session?
Commissioner Sturtz, Madam Chair, the only additional update from last session is that we did serve our initial disclosures yesterday, and then anything else we would recommend that we discuss in executive session.
Okay, well, any other comments or questions? Okay, well, I agree with Ms. McNulty that we wait until Mr. Herrera comes, and it's now 3:06 p.m., so if we could enter into recess, and hopefully we'll be back shortly.
Madam Chair?
Mr. Sturtz?
Would you please give me a call when Mr. Herrera either arrives or calls?
Okay, yeah, well, I probably wouldn't be the best person, probably Ray.
No, that's fine. I'm just not going to sit on hold waiting for Mr. Herrera to arrive.
Okay.
Thank you.
Commissioner Sturtz, what number would you like us to call you at? Whoop. Okay.
3:19 p.m. and we'll exit out of recess and back into public session. Let's do a roll call just to make sure everybody's on the line. Vice Chair Freeman?
Here.
Vice Chair Herrera?
Here.
Commissioner McNulty? Here. Commissioner Sturtz?
Here.
Great, we have a quorum, we're all present. And we were on agenda item 2, Mr. Herrera, just for your information. We covered the rest of the agenda in the first 35 minutes. So we're now, we went out of order, and now we're going back to agenda item 2. And Ms. McNulty put a motion on the table to go into executive session to obtain legal advice on the 5 items listed in the agenda. And it was not seconded, so that's kind of where we are. I'd entertain.
Madam Chair,
Yes, go ahead.
I understood from legal counsel that it's their recommendation that we discuss agenda item 2 in executive session, and that they just gave us the update they felt they could give us in public session. Is that correct, counsel?
Madam Chair, Commissioner McNulty, that's correct. It's our recommendation that the discussion be in executive session.
Well, I would move again then that we go into executive session for the purpose of obtaining legal advice and giving direction to counsel on agenda item 2.
Is there, was that Mr. Herrera?
That's correct.
I'm sorry, Mr. Herrera, I can't hear you.
I second that motion.
Okay. Any discussion? All in favor?
Aye.
Aye. Any opposed?
Nay.
Nay.
Okay, with that, it sounds like there were 3 ayes, McNulty, Herrera, Mathis, and 2 nays, Freeman and Sturts. So with that, we'll go into, exit out of public session and go into executive session once the public has cleared of the room. It's now 3:21 p.m. To public session, the time is 4:35 p.m. I want to thank our legal counsel for providing us advice in executive session on the different matters that are on the agenda. I'll entertain a motion if there is one.
Madam Chair, this is Linda. I would move that we direct legal counsel to proceed in accordance with our discussion in executive session, and in particular that we direct them to pursue legal avenues to release the executive session transcript associated with our selection of strategic telemetry, the date of which they're aware of, but I'm not. But I'm referring to the one that the federal trial court in Harris directed us to discuss in court.
Thank you. Is there a second? Okay, well,
Madam Chair?
Mr. Herrera?
Yeah, I would like for, if at all possible, to either Joe or Mary explain why these records are being released. These particular records, because obviously we have many, we've met many times in executive session. So why these particular records? And if Mary or Joe can elaborate on that, I'd appreciate that before I decide to vote either way.
So can we have that discussion before the motion is seconded?
Madam Chair, this is Joe. I would suggest that we have that discussion after there's a second.
Am I allowed to second it?
Madam Chair, it's our opinion that you have all the rights of the other members of the commission, that you may second the motion for purposes of discussion.
Okay, I'll second the motion. So any discussion?
Madam Chair, members of the commission, this is Joe. I think first thing I would note is Commissioner McNulty mentioned that she didn't have the specific dates. I think the dates that she was referring to of the executive session discussions were June 15th, June 24th, and June 29th of 2012. Yes. Sorry, it's 2011. I'm losing track of time here. And the Commissioner Herrera had asked for clarification as to why this issue, why these specific transcripts are the subject of possible release. The reason, as we understand it, is that these particular executive session transcripts involved the discussion of the selection of the Commission's mapping consultant, including evaluations of the proposals by the mapping consultant companies that were wishing to do business with the Commission. The open meeting law prohibits executive session transcripts from being released except under very limited circumstances, which arguably don't necessarily apply here. The reason that, as we understand it, that the Commission is considering releasing or seeking legal avenue to release these transcripts is because in the federal proceedings in Harris versus Arizona Independent Redistricting Commission, during the trial the last week of June, questions were asked of the commissioners who were called as witnesses by the plaintiffs with respect to these executive session transcripts and discussions. The Commission, counsel for the Commission, had been asserting all along that these transcripts were not public record, that they were deemed confidential by virtue of the open meeting law. And that argument was made to the three-judge panel, that noting that during the depositions of the commissioners, counsel for the plaintiffs respected the Commission's assertion of confidentiality with respect to those transcripts. But in trial, questions were asked by plaintiffs' counsel with respect to these executive transcript discussions. Counsel for plaintiffs argued to the panel that to the extent that these transcripts were confidential, the confidentiality no longer existed because of the discussion of confidential documents, which were procurement documents of sealed bids at the time, were no longer sealed after the decision to select strategic telemetry was made. And also the counsel for, in fairness to the plaintiffs, argued that the Commission has asserted during the course of the procurement for both outside counsel and the mapping consultant that the procurement code, although while being followed by the Commission, did not apply to the Commission. So therefore, the extent that documents are confidential under the procurement code and the exception under the open meeting law for discussions in executive session with respect to confidential documents did not apply in this situation. Nevertheless, the court agreed with plaintiffs and allowed questions to be asked of the individual commissioners with respect to these executive session discussions, and many questions were in fact asked. So not all, of course, but a lot of the discussion in those sessions was discussed in open court during the federal proceedings in Harris versus the Arizona Independent Redistricting Commission. So at this point, because the issue with respect to these discussions may in fact be relevant in the Leach case that's coming up, and also in fairness to all involved in those discussions, I understand the direction through this motion would be to pursue releasing these transcripts, and the direction is to counsel to pursue legal avenues to do that, which we would do if the Commission so directs us to do.
Thank you, Mr. Canfield. Any questions from commissioners or comments?
Madam Chair, do you have a follow-up question, Mr. Canfield?
Go ahead.
Mr. Canfield, we start releasing executive session meeting minutes. What stops the attorneys, whether it be or the opposing attorneys, to keep asking for more information in executive session? We've already released these transcripts. Why not more? I think that, I don't know if it's a question, but I guess I'm a little worried about that. When we start releasing these transcripts, And I was told every time we start a meeting, there's, if everything's confidential, remains within the people that are in the meeting. But it seems less and less of that is true. And I'm a little concerned about that.
Madam Chair, Commissioner Herrera, that's a fair question. I understand that the motion is specific to these particular transcripts because of the unique circumstances that we find ourselves here with the federal courts allowing of questions to be asked about confidential discussions in executive session. So I don't know how to answer your question about whether others may pursue release of executive session transcripts. All I can say for now is that these executive session transcripts and discussions are specifically deemed confidential under the open meeting law. We know now clearly that the open meeting law does govern the proceedings of the commission as a result of the Court of Appeals decision in State v. Mathis, and we can't even say for sure whether there is necessarily a legal avenue to release these transcripts in light of the prohibition on release of in light of the confidentiality for executive session transcripts. So I think that my understanding is this would be a very narrow, limited request for us to look into, and only because of the federal court's decision to allow questions to be asked in trial with respect to these transcripts over the objections of the commission.
Madam Chair, could I have a follow-up question to Mr. Canfield?
Sure, go ahead.
So these transcripts are being released because we have commissioners that spoke about them in court. So it's very possible that their attorneys can be asking questions about some other meeting that happened in executive session. These commissioners could talk about it, and it pretty much the same. We could probably pretty much get the same result. That's also a possibility. So I guess what I'm asking, my question is to you, what would be the negative consequence by us not releasing these documents or not voting to release them to the public?
Madam Chair, Commissioner Herrera, I'm not sure what the consequences would be if the commission decides not to. I mean, we're just taking direction from the commission. My understanding as counsel, and just listening to the discussions, is that because the discussions in these executive sessions are now public in some respect, but not in all respects, that perhaps it may make sense for the whole entire discussion to be made public. But we will respect whatever direction the commission gives us, because it is our position and our advice that executive session transcripts and discussions must remain confidential, except under the very limited exceptions provided in the open meeting law, which we don't believe necessarily apply here.
Thank you.
Any other questions or comments from other commissioners?
I do have a comment, Madam Chair, if no one else has.
Go ahead.
Following up on what Mr. Herrera said, and I think what he raises is very important. I support, well, first of all, let me clarify my motion by saying that in asking counsel to pursue legal avenues to release the transcripts, I am not requesting that they release them unless the commission votes to release them after receiving advice back on what they've determined. I also think but I would, at least as I sit here now, prefer to release them because they have been partially released. And I think it's important that folks understand the entirety of what's in those transcripts. I think we've been hamstrung from defending ourselves for a lot of months in a way that was unnecessary and would be resolved if those were released. Having said that, though, I think that we as a commission should vigorously pursue a violation of the open meeting law if it occurs in connection with any future transcripts. So I wouldn't want, in pursuing legal avenues to release those, I wouldn't want to in any way suggest that we're agreeing to release the other transcripts. We don't have the time to go through them. We can't. We don't have the resources to make our lawyers go through them and see what's attorney-client privilege and what's legislative privilege. And we all, we're in executive session at the direction of our legal counsel and the direction of the State Procurement Office. And I'm not suggesting and don't want us to take any action that somehow suggests that that's no longer relevant.
Madam Chair.
Madam Chair.
Did Mr. Canfield want to say something first?
Yes, Madam Chair. I'm sorry to interrupt you, Mr. Herrera, Commissioner Herrera. I don't recall if the motion indicated that that attorney-client privileged advice in those transcripts should be redacted, and that would be our advice, and that may require an amendment to the motion.
Yeah, I didn't address that in the motion, Mr. Canfield, because my understanding is that we wouldn't be releasing anything now. We would make that decision at a later time once you determined whether there was an avenue pursuant to which we could release them.
That was my understanding as well.
Got it. Thank you, Madam Chair. Thank you, Commissioner McNulty.
Mr. Herrera, did you have something?
I do, and it's either Ms. O'Grady or Mr. Canfield can answer this question. Have any of the commissioners violated open meeting laws in any of their testimony or in any discussions they've had in the open? Because if they have, this is something that we need to address. We have executive meetings, and every time we have an executive meeting, our chairwoman has that disclaimer in the beginning. So there's a reason why she mentions that disclaimer or that let's say warning. But I guess I want assurance from you guys, from both our attorneys, that none of the commissioners have violated open meeting laws.
Madam Chair, Commissioner Herrera, I think your question is, by virtue of your testimony in federal court, did you violate the open meeting law? Is that what you're asking?
No, not necessarily. That could be part of the question, but I'm also asking, has there been information given to the public or to attorneys that did not have this privilege because they weren't participating in the executive session, that those questions weren't even asked? These commissioners chose to voluntarily release this information. So it's more than just what happened in the trial. It's more than that. It's talking about did commissioners voluntarily released information when they weren't even asked questions that pertain to that. Meaning they started just talking about stuff that happened in executive session, knowingly that violated open meeting laws.
Madam Chair, Commissioner Herrera, I'm drawing a blank. I have to go back and look at the transcript from the trial. I thought that the questions asked were answered appropriately and objections were made if the person or witness testifying went beyond the scope of the question. So I really don't feel like I'm in a position to give you an answer as to whether something was revealed that was outside the scope of what the court ordered to be revealed through the questioning at trial.
Mr. Canfield, then can you at the next meeting, before the next meeting, do some research on that to see if that is indeed the case, that none of the commissioners violated the open meeting laws? And again, I'm not referring to questions that were asked and you opposed, and then the panel decided with the commissioners, with the commissioners' attorneys that is not privileged information. I'm referring to any other information that was not even asked. These commissioners chose to voluntarily release this information, whether to the press, whether to whomever, and these individuals had no right to be, had no privilege to this executive meeting information. So I would appreciate if you, at the next meeting, give me a definite answer.
Madam Chair, Commissioner Herrera, I'll just answer for myself. I don't think it would be appropriate for me to go to looking into whether arguably a commissioner violated the open meeting law unless the commission as a whole specifically directs me or Mary to, or both of us to do that. I think if you're asking in the scope of the trial, well...
No, I was not. I was not. But, you know, what is the point of having executive session meetings if they're really not confidential? And you can't even guarantee me that. So I think it is very appropriate. Again, before we go into executive meetings, and if the chairwoman wants to read that paragraph she always reads, for us to be reminded, then I would love for her to do that. But if you can't guarantee me that these meetings are truly confidential and talking about them to the public violates the open meeting law, if you cannot assure me that, then why bother going into executive meetings?
Madam Chair, just a comment on I think the motion on the floor. Do I need to if I need to restate that at any point, let me know. But my understanding was that the court, the judges, at least in this case, made a comment that we could testify if asked about that transcript, and so I think that came from the bench. But that's probably not on our agenda here right now.
Okay.
Madam Chair, it's Scott Freeman.
Mr. Freeman?
A couple things. Perhaps if Commission's counsel is going to follow Commissioner Herrera's directive, they need to identify themselves as persons with knowledge of potentially relevant facts in the ongoing litigation. I would like to know from Commissioner Herrera what specific facts is he aware of? What is he insinuating? Because I know I was at trial, I remember it very well, and a 3-judge panel directed me to go ahead and answer the question that was posed to me. So what specifically are you referring to that is outside the context of the recent trial?
And Commissioner Freeman, that's a valid question. I don't know the answer to that. That's why I'm asking our attorneys to ask them a very simple question. Can you assure me that none of, and I'm including myself in this, none of the commissioners have violated open meeting laws? And if they have, we need to know about it, because I want to make sure it doesn't happen again.
Well, I assume your question...
Can I finish? Can I finish?
I thought you were. Keep going.
Well, I'm not. Thank you. I'm not asking our attorneys to drop the hammer on these commissioners, because it could be me. I could be one of those people. But I do want to know if commissioners, I'm including myself, there's 5 of them, have violated open meeting laws. And I'm not talking about what happened in the court in the trial, but again, talking to the press, talking about things that happen in executive session, and when they really shouldn't be. And I think, again, I'm not referring to the trial, because if it is happening, I want to make sure that stops. And I'm including myself in this. I'm not excluding myself in this at all. I'm one of the commissioners, so I'm not insinuating anything. What I am doing is making sure that we follow procedure. If we go in executive session, I want to be comfortable, as well as the other 4 commissioners want to be comfortable, that anything discussed in there stays within those individuals that are part of the discussion in executive session. I think it's a very legitimate question to ask. And I want to feel comfortable when we go to executive sessions that the information does stay with the attorneys and the commissioners and the other individuals that are attending these executive session meeting minutes.
Madam Chair.
Mr. Freeman?
Well, a couple things. Perhaps then we either need to have the commission retain the services of a private investigator to conduct that, because I don't believe the commission's counsel can do that. Or 2, perhaps we should enter some sort of consent decree with the county attorney to allow him to reopen his investigation of alleged violations of open meeting laws for the entire span of the commission.
They were alleged and they weren't proven. So yeah, if you want to rehash that over again and waste state money, then go ahead. But what I'm getting at is I want to be assured that when I go into an executive meeting with our attorneys, with the commissioners and the ASCPA staff, maybe just Ray, maybe Christina, that the things that we discuss in these executive sessions are truly confidential, and we won't be releasing these transcripts just because a commissioner brings it up in public, outside of the court.
Madam Chair.
Mr. Freeman?
Well, I'm responding to your concerns, Commissioner Herrera. Let's go ahead. If you've got these great concerns, I want to respect those concerns. Let's go ahead and reapproach the county attorney and propose some sort of consent order that will allow him to reinstitute any and all investigations of alleged violations of the state's open meeting law by this commission or any commissioners.
No, I think you're misunderstanding me. I don't have any particular allegation in mind because there haven't been any that I know of. But what I do want to know is if our attorneys feel comfortable saying no violation has occurred. If they can tell me that, because I trust our attorneys, Mary and Joe. If Mary and Joe can assure me that no violations have occurred, that they're aware of, you know what? I'll move on.
Madam Chair.
So I'm not alleging anything happened. What I am asking is for our attorneys that we hired and pay, that I have full confidence in, to reassure me that no open meeting laws have been violated. I'm going to move on from this issue.
Madam Chair, Commissioner Herrera, I think this is far afield from our agenda item today, and so we'd be happy to follow up with you after the meeting on this issue, but I do think we're getting far afield from the motion that's been made and the agenda that we have here.
Mr. Great, but this is the agenda item is about releasing executive meeting minutes, and that's my concern.
Well,
and I think this concern that I'm voicing is everything to do with what we're talking about right now.
Well, Mr. Herrera, what we're doing today is just having legal counsel pursue legal avenues to see what's even possible with releasing these particular executive session transcripts. And we'll be coming back to the commission as a whole to have a vote as to whether or not anyone wants to release them once we have that information.
Okay.
So any other comments or questions?
Madam Chair.
Mr. Freeman?
I guess one question I would have then is in the Leach matter, are there any other executive sessions that are implicated by the allegations brought in that matter?
That's a good question. Legal counsel, do you know?
Madam Chair, Commissioner Freeman, we don't think so.
Okay, any other questions?
Madam Chair, can Commissioner McNulty reread, or someone can reread the motion, or the amended motion?
Sure, yeah. Ms. McNulty, do you want to?
I'll try and restate it. I move that we direct our legal counsel to proceed in accordance with the direction that we provided them in executive session, and that we request that they examine legal avenues which might be available to release the transcripts concerning retention of strategic telemetry dated June 15, Joe, you're going to have to help me here, June
24th and 29th.
Thank you, June 24th and June 29th, with the understanding that they will not be released in the absence of further discussion and a vote by the Commission.
Thank you for clarifying. I would approve that motion.
Okay. It's already been seconded, so
Okay.
Any other discussion? All in favor?
Aye.
Aye.
Aye. Aye. So any nays? Okay, hearing none, so a unanimous decision. So legal counsel, you'll let us know, and I guess we'll have to notice a meeting once we have that information. Unless that's something you can, yeah, I would think, I don't know if that can be done without having a meeting or not. I would think, I don't know if you could give us a memo.
Madam Chair, I think under the language of the motion, as I understand it, it would require another meeting.
Okay.
If I understand it correctly, the meeting would be whether we would approve the recommendation given by our attorneys once they gather whatever information they need.
Yes.
That was the motion, I thought. I mean, so you could still send us information for us to review before the meeting. Is that I understanding correctly?
Although we may want to have, they may decide that that's something we should receive in executive session. So let's
Okay.
see what they come up with.
Okay.
Okay, other comments or questions from anyone?
I got to go do some work. Can we?
I have a comment I'd just like to make before we close, because a lot was said last week on this particular agenda item in public session. And even though we all agreed that silence did not mean consent, I just want to say a couple things. One is that Mary and Joe and your fellow attorneys at Osborne, Maladon, and Ballard Spahr, respectively, you were hired to defend the decisions of the commission because you're representing the commission as a whole. And some of those decisions include, of course, two maps, a legislative map and a congressional map that got approved by the majority of the commissioners. You have done a superb job under extremely difficult conditions in representing the commission as a body. And if I could do it all over again, even knowing everything I know today as well, I'd make the same decision. And I just want to thank you and your fellow attorneys and counsel for just giving us great advice and sticking with us through this, through really difficult conditions. So thank you.
Thank you, Madam Chair.
Mr. Herrera?
Yeah, I think I've probably made those same comments as you did, probably not as eloquent last time. You know, the commission will, in 10 years or 9 years from now, whatever I think it's 8 now, we'll go through this whole process again, and they'll go through, obviously, selecting commission, unless something changes drastically, which it might, but if it doesn't, if everything stays the same, they'll select commissioners, maybe 5, maybe more, and after that, they'll select their legal counsel, and if asked, I don't even know about, I may not be asked, but if asked, I would recommend Mary and Joe over again. And that's even recommending Mary over my favorite attorney, but I would even do that in 8 years from now, that I think they did a superb job. Mary representing the commission and Joe representing the commission. Again, we selected him as a Democratic attorney, a Republican commissioner, but I never felt that way. I never felt that Joe was a Republican, therefore I couldn't talk to him. And Mary was a Democratic attorney, therefore I needed to have more faith in her. Never felt that way. And I hope when they select a commission next time, I hope I am asked, and I will highly recommend that they hire these two attorneys and their law firms, because they did the best job they could. This is a difficult position they were put in, and yeah, I'm extremely happy with the service and the advice they provided me, and I would love to have them again as attorneys. I would recommend them again as attorneys for the next commission. So I echo those same comments. Thank you.
Thank you.
Madam Chair, I'll just add, and I'll thank you for making those comments. I agree with everything you said, and we'll add that Joe and Mary put partisanship aside to represent this commission in a professional way, and that's what lawyers are supposed to do. And I too would make the same decision again. I think it's one of the best decisions we made as a group.
Yeah. And Madam Chair, one last comment, and then I'll stop talking. The same for me goes to strategic telemetry. Again, they were all these insinuations that they were a Democratic mapping consultant, and they did a job that I was expecting, but they went above and beyond. I really think that they were fair, impartial, and I would also recommend them as well. So and I think I reminded everyone last time that our maps were approved on the first try, pre-cleared on the first try. That has never happened before. And again, I think it's easy for us to forget all this and pat ourselves on the back when all these lawsuits are taking place. But again, our attorneys and our mapping consultants, we couldn't have hired better ones. And again, I can't thank them enough.
I would agree with that, and I would also just add our staff to pile on.
Of course.
So I think the entire team that we put together was superb, and I'm grateful for all of their continued work on the Commission's behalf. Any other comments or questions?
Madam Chair,
Mr. Freeman?
unfortunately, in my opinion, the commissioners were not independent, and as they were supposed to be, pursuant to the constitutional provision that gave life to this commission. We were often lectured and told during commission hearings about how many times the Constitution uses the word independent to describe this commission and commissioners. It's over 30 times. And yet, one thing the Harris trial did is it shined just a little bit more light on what transpired, and sort of gave credence to, I think, comments that I made and what I think everyone really knew at the time, is that the commission was implementing partisan maps. So before we leave agenda item 2, I'm not sure if I'm completely comfortable just leaving it, because I'm not sure whether we've completely addressed the issue of a potential conflict of interest or things of that nature with respect to representation of individual commissioners who have been served with process and who are parties in their official capacity in the lawsuit. So I'd just like to make a motion that for any commissioner who feels it is necessary, that the commission approve that the engagement of their individual counsel can be expanded such that that counsel can advise them on all aspects of the litigation and appear as counsel of record for that individual commissioner or commissioners, with the provision that that counsel is only authorized to articulate, in addition to what they're already authorized to do, which is advise on issues of privilege and discovery matters. But beyond that, they're only authorized to articulate a position of that individual commissioner in the matter where appropriate and under governing law.
Okay, is there a second?
Second the motion.
Any discussion?
Madam Chair?
Mr. Herrera?
No, I do have some discussion. I think Commissioner McNulty said she needed to leave, so I don't know how much time we have. I was hoping we would devote more time to this and at the very end of the meeting. I think Ray Bladine sent out an email not that long ago. I may have looked at it yesterday about some of the questions that came up in the billing, some of these billings that our attorneys submitted, and one of the attorneys submitted a billing for investigating Commissioner Mathis. At the last meeting, I was more than okay with allowing commissioners to get their own representation, but not for a witch hunt. I would never approve that. I think it is a waste of state money, and if that's what our motion will be, is to allow these attorneys to do their own thing, to do a witch hunt of a commissioner, do some research on opposing research on the chairwoman. Then no, I wouldn't approve the motion, and I won't. I was not happy with what I saw in that letter, and I would not support this motion if it's this broad and allows attorneys to do pretty much what they want without really us defining what they will be doing, what work they will be doing, and what work they can bill for and what they cannot. So those are my comments.
Thank you. Other comments?
Madam Chair.
Ms. McNulty?
Yeah, my only comment is that if we're going to spend money like that, then we as a commission should be spending money to investigate who it is that's paying the plaintiffs and their lawyers, and has been paying them for 3 years now to try and bring this entire Independent Redistricting Commission down. And we should also investigate Mr. Mills and his relationship to Commissioner Sturts and Commissioner Freeman, and his relationship to the people who are paying the plaintiffs Mr. Cantelmi and Mr. Liberti and Ms. Hauser. We don't need to be investigating one another on commission money. And I'll just make one more statement to Mr. Freeman. He enjoys making sanctimonious statements about how independent he was and the light that was shed on what went on in this commission. I made my own independent decisions. I did not submit any partisan maps of any kind. And if we want to have, a real full disclosure of everyone that everyone talked to in relation to working on the maps, maybe someday we can get to that. But the fact that any of us had conversations to educate ourselves or to make ourselves better able to do the job we were supposed to do does not in any way mean that we were not independent. And I know there's probably no one there to listen or who cares about that, but that's my only comment. I'll vote no on this motion also, and I've got to drop off pretty soon.
Madam Chair, I have one more comment, and then I will also I won't say anything after that. This is a record that we can easily look at the record. There was multiple times when we were voting on certain topics, on certain issues, that Commissioner McNulty didn't side with me. She sided with either with the Republicans or Commissioner or Chairwoman Mathis, and even after in meetings wanting to let her know the reasons why I was voting a certain way, usually, especially if those are votes that I was opposed to and she was for, or vice versa, she maintained that independent streak. She didn't vote the way I voted. I'm going to say the majority of times we had some disagreements. And again, the record's pretty clear. There's probably no one in the commission probably more independent than McNulty, and it's odd that I say that considering she's a Democrat. So anybody that impugns her record or her reputation is really not being honest. I have the most respect for Commissioner McNulty, and I wish she would have voted with me 100% of the time, but that wasn't the case. And it was frustrating for me, as it was frustrating working with Commissioner Mathis on certain things, because she, again, independent. And I'll admit I'm probably the most, out of the three people that I just mentioned, including myself, I'm probably the most biased. But I did everything I could to maintain to be as independent as possible, and seeking input from pretty much anyone that would talk to me during the meetings. But again, I wanted to make sure that I was pretty clear and for the record that Commissioner McNulty extremely independent, very bright, and I think she did. I think out of all commissioners, did a research before she came to meetings, and I think the transcripts prove when she would talk about areas that she wasn't even familiar with because she didn't live in the area. She knew them well because she did her research, not because she was handed a map to recite things that somebody else did. Not even close. She knew her stuff because she did her research before the meetings, and that's how she approached every meeting. And I'm very honored to have served by her. And I think I learned a lot from her, and I think most commissioners, if not all commissioners that served with me, probably learned a lot from Commissioner McNulty. So if anybody accuses her of not being independent, not doing her own work, is not being honest.
Thank you, Mr. Herrera.
Madam Chair.
Any other comments?
Madam Chair, if it's useful, I'm trying to understand kind of the scope of the motion and describe kind of what from Commission Council we viewed, because we do think there's an appropriate role in Leach for, as there was in Harris, for Commissioner Council. And again, back in December, the court this commission, authorized separate counsel for commissioners, and so we do think it's appropriate to have Commissioner Counsel on the issue of legislative privilege and waiver, as they did in Harris, and for certain discovery-related work. All subject.
Madam, Ms. O'Grady, we already discussed that, and that was embodied in the motion we gave you to proceed in accordance with the direction we gave you in executive session.
Okay, so that was unanimously approved, so that we will pursue the role of counsel, and so that's part of the reason for my confusion. This scope, since that was approved, we'll move forward with that. This would then add for all commissioners the authority to have a lawyer who would serve as their advocate, their personal advocate, for their personal positions in the litigation and use the commission's budget for that purpose. As I understand the motion, that goes, well beyond what the motion was approved and the role of commissioner counsel. So because that motion had been approved, I just wanted to make sure that I was clear in terms of how far beyond this motion will go from what the commission has already adopted.
Madam Chair, it's Scott Freeman.
Mr. Freeman?
Not quite. I mean, I think it was within the context of the litigation and under governing law. So you use the word individual, and that's what, maybe I'm quibbling, it's a quibble, but every commissioner has been named in their official capacity in the lawsuit. And this would allow the individual counsel, if a commissioner so wanted, it would expand the scope of engagement from what it currently is. It would allow those individual counsel to assert positions on behalf of the individual commissioner, not on behalf of the body, and to appear in the lawsuit.
Yeah, go ahead. I would like you to read it again. Go ahead.
Well, I was looking at notes. I wasn't, but I'll try to reconstruct it as best I can. The motion was that for any commissioner who so chooses to pursue this option, that the scope of engagement for the individual counsel that the commission's already retained for them be expanded such that that individual counsel could advise that commissioner on all aspects of the litigation and appear as counsel of record for the individual commissioner or commissioners. However, the counsel is only authorized to articulate positions of the individual commissioners as they are named in the lawsuit before the court and where appropriate and under governing law.
Madam Chair, and I don't know what the where appropriate and under governing law. Mr. Canfield previously has explained what we view as appropriate and governing law, which would be inconsistent with the scope of, with the description that Commissioner Freeman has given. Because we view, as Joe explained, the commissioners are named in their official capacities as proxies for the organization. And it's really inseparable in this type of official capacity litigation that challenges the maps and seeks relief only against the commission and seeks to enjoin only the maps, seeks no relief against individual commissioners, where applicable law means that the real party in interest here is the commission as a body. And so that's why the clause where applicable seems inconsistent with the scope that is described in the earlier part of the motion.
Okay, any other comments or questions? All in favor?
Aye.
Aye.
Any opposed?
I'm opposed.
So opposed as well.
I'm opposed as well. So sounds like Sturts and Freeman are voting aye, and Mathis, McNulty, Herrera voted no. So there is a role for individual counsel, as we all know, and that's already been approved back when we were talking about our defense in Harris. And so that continues. Same thing goes in Leach. If in the future an individual commissioner, if something else arises that, we just can't foresee at this time in terms of, another charge or something that requires independent counsel, I think at that time we can get together as a commission and talk about, whether that warrants an expansion of scope for individual counsel for that particular commissioner or commissioners. But I think we really have to be mindful of what is happening with our budget, since it's been strained significantly through what's happened in this past trial, with everybody having individual counsel and some charges that I find quite surprising and not necessarily something that was approved as part of the scope. So we'll just have to, I think we'll have to deal with things on a case-by-case basis moving forward.
Madam Chair?
Mr. Herrera?
Yeah, I believe the AC in my office has been turned off, so I will have to hang up because it's hot. But what I want to do, just quickly, any invoices that are submitted that have questionable charges, I would like for Mr. Bladeen to present those to the board before they get paid. Because again, to me, it's not an issue that the state doesn't have money. Because I think if it's important for the commission and individual attorneys, then we should get this paid. But my main concern is spending money on things that we did not approve. And again, investigating the chair is not something that I would have. That I do believe strongly that it is not what was intended for getting individual attorneys. So maybe he's already doing this, but Mr. Bladeen, if there's any questionable charges like the one you emailed to us, that you continue to do so, because I want to be made aware of that. Because the reason I changed my mind, I was so ready to vote for this, but then I received that email, and that really was disturbing. And I don't want to say disgusting, but I guess it was close to disgusting, if not disgusting. And I would never approve that. I would never allow a commissioner's attorney to basically conduct a witch hunt of another commissioner, whether it be a Republican, Democrat, or Independent. That's not what we're here for. So hopefully Mr. Bladeen has heard what I said, and we'll bring those, when they do come up, we'll bring those questionable charges back to the commission.
Madam Chair?
Mr. Freeman?
Well, perhaps you've forgotten already, Commissioner Herrera, but one of the charges was for your attorney. So I would expect to find out what those questionable charges were about, just as everyone has learned about what allegedly the charges by Commissioner Sturtz's attorney were about.
Madam Chair, the charges for there was a sentence in that that my attorney went over what was projected, which I would love to know what any questionable charges. Definitely sharing with everybody. But there was no amount given to Commissioner Sturtz's attorney in terms of how much he went over by, and that, to me, that's a concern. So if in the future, Mr. Bladeen, when you mention things like that they went over budget, then I want to know by how much. You stated how much I went over budget, or my attorney did, at least the number of hours, which I would like more detail, including for my own attorney. So I want to be as consistent as possible. I agree with Commissioner Freeman. This pertains to me as well. If there's any questionable fees that the attorney representing me submitted, I want to be made aware of that. I wasn't made aware of that only by that couple of sentences. So in the future, or even for the last email we received, more detail for me is best.
Madam Chair?
Mr. Bladeen?
I think it's the responsibility of the executive director to review invoices and approve them, or if there is a significant issue, bring it to the commission. And I realize that I'm not going to always make everyone happy. I tried to do that with this memo. I haven't had issues in the past that were of this scope. I keep the individual billings have been kept as confidential. I think if we get into too much detail of this, we'll start to have problems with legislative privilege on the materials and client attorney privilege. I believe we talked about this quite a bit before Commissioner Herrera was able to be here. I certainly will continue to review them, and if I see something that's significant, bring it forward. I've contacted the two attorneys involved, and there may be good explanation for things. If there are, then I believe that I should have the authority to make a decision about whether they're paid or not, and if I deny it, the attorney can always bring it forward to the commission and have you decide. But I think we have to be very careful of not having the commission approving all the invoices for all the attorneys, because it will get very, very messy.
Madam Chair, now I will have to go after I make this comment. My intention was not for you, Mr. Bladine, to bring up every billing, every invoice to the commission, because I trust you enough to make a decision to approve them. But as you did with these particular invoices, you did send the commission some of the questionable ones that you thought, or at least if they went over, okay. But then you addressed a questionable fee, a questionable charge. And that's all I'm asking. I think you're already doing that, and I apologize if I meant to, if I confused the issue. I think you're already doing that, and I appreciate that. But I would want, when I do follow up, I would want some more information. And I won't always want information about everything, but if it's something that you feel, you as a professional feel that that these are questionable, then yes, I want to know. But then that's, again, I didn't mean to add more duties to you. Since I think you're already doing what I was talking about. But again, there's no AC here, so I'm going to have to leave.
Before you go, Mr. Herrera,
Sure.
before you go, I think it's important that each commissioner reviews his or her own invoice that they have with their individual counsel to ensure that, it's accurately reflecting their recollection of what occurred. I know I do that with mine, and I just think it's important that each individual, and this isn't just being given to Mr. Bladine to do.
No, I thank you, and you're right. And I have reviewed the invoices. I didn't see any questionable charges. Now, it went over projected amount, but the reasons why he went over projected were, to me, extremely reasonable. But I think when Mr. Mandel contacts Mr. Bladine, I think he'll realize, he'll know the reasons why he went over projected amount. So. But again, very valid. So, but thank you.
Okay, thank you.
Take care.
Any other comments or questions from anyone else?
Can I go home?
And just wait till we adjourn, and then.
Oh, okay, Madam Chair.
Okay, I'm not hearing any other comments or questions. The time is 5:31 p.m. and this meeting is adjourned. Thank you.
Thank you, guys.
Thank
Take care.
you.